following charges. A, on count 3, public violence in respect of accused 1, 8 and 9. B, count 22, unlicensed trading in firearms in respect of accused number 10 and 11. C, count 29, conspiracy to commit murder of Mr. Booth in respect of accused 2. Count 37, attempted murder of Mr. Nadeer in respect of accused 2. Count 77, money laundering accused 2 with reference to Annexure 14. Count 96, fraud accused 2. Counts 103 and 105, corruption, which the state termed a duplication in respect of counts 1, 13 and 14. The court will get back to those charges again. Additionally, during argument, they consider that the accused 1 is entitled to be discharged in respect of count 92, the intimidation charge involving Captain du Plessis. Ordinarily, when a court grants a discharge, it provides reasons as it amounts to a final judgment. However, the concessions made by the state is an indication that the dispute between it and the several accused in respect of the applicable charges they are has been laid to rest, because they are of the view that on these charges there are no evidence on which a reasonable man might convict in respect of those accused on the charges referred to above. I agree with the state, except in respect of counts 103 and 105. Given these concessions, the state is of the view that there is no evidence, which I said, on which a reasonable man might convict the accused. Therefore, the court makes the following findings. Accused 1, 8 and 9 are found not guilty on count 3, the so-called public violence charge, and are thus entitled to the discharge in terms of section 174. In respect of count 22, the so-called trading in an unlicensed firearms, the court finds accused 10 and 11 not guilty, and they are discharged on those charges. Accused number 2 is also discharged in respect of count 29, conspiracy to commit murder of Mr. William Booth. With regards to count 37, the attempted murder of Mr. Andre Nadeer, the court finds accused or grants the discharge to accused number 2 and finds him not guilty. In respect of count 77, the money laundering charge, accused number 2 is also granted a discharge and is also found not guilty and accordingly discharged. Lastly, the court grants accused number 2 discharge in respect of count 96, the so-called fraud charge, which is set out in the indictment. In respect of counts 103 and 105, there is uncertainty whether the discharge can be granted in law at the stage, for the reasons that I state here under. The charges listed under counts 103 and 105 seems to be a clerical duplication of charges of counts 102 and 104. And not a duplication of charges where the state included these offences because there was uncertainty as to the facts that can be proved, which offences the accused may be indicted upon as contemplated in section 83 of the CPA. It is therefore not a duplication in the true sense of the word. Thus, it would be inappropriate at this stage to grant a judgment on those charges which would still remain on the facts underlying count 104. This is because it's not the state's contention that there is no evidence upon which a reasonable man might convict. Should discharge be granted, it has as a consequence that the facts and evidence upon which those charges are based, that notwithstanding how it appears to be cited in the indictment, would not be enough to sustain the conviction. That would be the consequence of granting a discharge at this stage. The granting of a discharge is not a mere mechanical exercise like the drawing of a line through a charge on which an accused has been indicted and pleaded. The granting of a discharge in terms of Section 174 is based on the substantive evidence led by the state during the presentation of its case, irrespective of how many times that charge is repeated and duplicated. I make the point with a simple illustration where, for example, an accused has been charged on the same facts and evidence under case number X in the High Court on the previous occasion, and thereafter the same accused is indicted once again on under a different case number Y in a different indictment or charge sheet. Such accused cannot be firstly charged and secondly convicted as that charge is based on the same evidence. And such accused has already been discharged and found guilty in terms of Section 174 on the previous occasion. Clearly, the discharge requested by the state is not meant to be on the merits. It is at this stage, as I said, not then to be appropriate to grant a discharge on these charges because of a purely erroneous clerical duplication thereof. Furthermore, as pointed out, the situation is akin to an unauthorized stopping of a prosecution in terms of Section 6B of the CPA. Firstly, because the prosecutor wasn't authorized to do so, and secondly, and more importantly, there was no intention on the part of the prosecutor to abandon the prosecution based on the evidence on these charges, wherever and under whatever count number it resides. It was clearly at this stage, as I said, a matter of proper housekeeping of the prosecution's case by weeding out what seems to be an unnecessary revisitation of charges. If it is to be construed to be such an action, it would amount to a nullity. It seems clear that this was clearly an error on the part of the prosecution. Almost a century ago, Lewis J.N. Arthur Hepworth, 1928, 265 AD, said the following of what the judge's role in a criminal trial. A criminal trial is not a game. And the judge's position in a criminal trial is not merely that of an umpire to see that the rules of the game are observed by both sides. A judge or an administrative justice is not merely a figurehead. He has not only to direct and control the proceedings according to recognized rules of procedure, but to see that justice is done. This principle is firmly entrenched in our law. Furthermore, I disagree with the prosecution that the accused number 8 and 9 should not be granted a discharge on counts 4 and 5. This is the murder and attempted murder of the stabbing, where one person was stabbed and one person was killed at the Cubana incident. In respect of accused number 8, I am of the view that this charge should be granted in respect of counts 4, the attempted murder of Mr. Soho for Gang, and on count 5, the murder of Mr. Pitso for Lang Ngwalo. I am of the view that there is no direct or substantial evidence that has been presented from which the court would be able to draw an inference or inferences at a later stage that he shared a common purpose with the person or persons who stabbed the complainant in count 4, the attempted murder charges. Furthermore, there is no direct or sufficient circumstantial evidence adduced upon which the court might be able to draw inferences that, as the only reasonable inference, that he was a co-perpetrator or participant in any form in the murder of the deceased in count number 5. In respect of accused 9, I am also of the view that he should be discharged in respect of counts 4 and 5. There is no evidence that whilst accused number 9, being on the scene, was actively involved in the stabbing of either the complainant in count 4 or the deceased in count 5. The evidence upon which the state relies for the Cubana incident is that of Mr. Anwari, insofar as they submit that it implicates both the accused, who said that the accused were part of a group of people who were aggressive. He stated the following, and I quote Mr. Anwari's evidence. They were charging towards Sol, the head bouncer. I remember he had a white shirt, a black waistcoat, and just beside the door, Charl Kinnear was punching him in the face, and they made a circle around him. Nafiz was in that circle as well. It was extremely, how can I say, it was it was very violent. It happened very quickly. However, Mr. Anwari is unable to identify which of the accused stabbed the complainant and the deceased, or anyone, or that anyone was stabbed as per the following from the record. On questions, the court asked Mr. Anwari, do you know who it was that was responsible for the stabbing of those two persons? Mr. Anwari answers, Your Worship, if I may go into it, I did not know someone that was stabbed until 6 o'clock the next morning. And then the court asked, but you don't know who is or was? That's it. No, says Mr. Anwari. You can't say if any of the accused here, if it is any of the accused here. No, I can't. Then Mr. Anwari goes, it sounded like a boast basically, because I saw someone being punched, twice jogged, I punched so. But that's all the violence I witnessed no other violence. With regards to the incident the following day, he testified that he was not sure whether accused 8 was present at the meeting where accused 1 gave him the instruction to hide the persons responsible for the stabbing of the deceased. Even if the court should find that accused 8 was present at the meeting, it is not clear what role he played in the hiding of the said persons to, at the very least, make him an accessory after the fact to the murder of the deceased on count number 5. Thus, in my view, the evidence that the state presents is not evidence on which a reasonable man might convict accused 8 and 9, and consequently they are entitled to the discharge in respect of counts 4 and 5. The accused number 8 and 9 are therefore also, the court finds them not guilty at this on counts, entitled to discharge, and the court finds them not guilty in respect of counts 4 and 5. In respect of the remainder of the charges, it seems that basically the arguments of most of the counsel were based on the question whether the credibility of the witnesses implicating the accused are of such a nature that the court should grant them discharge. With all due respect to all the counsel that argued this, the arguments is a misapplication of the law and the misunderstanding of the law in respect of the principles underlying applications in terms of Section 174. Therefore, in respect of the remainder of the charges, the application for discharge is dismissed, on which the respective accused has either been jointly or severally is set out in the indictment which are applicable to them. As is customary in this matter, in matters like these, the court does not provide reasons for the refusal of the Section 175 applications. For reasons for such a dismissal will become apparent at a later stage. That is the order then of the court. Thank you.
All right, so there you have it. It seems we're reaching a final decision there in the Western Cape High Court, where the presiding officer is ruling on whether or not there should be a discharge in the case involving Cape Town underworld gang boss Nafiz Modack and 14 others. In some instances, he is conceding that they may not be found guilty of some charges, but it seems the issues around a discharge are those he simply wasn't convinced of. We'll get you a sense of what else was said.